ladies and gentlemen. Welcome to the Give Me 15 Minutes education program for medical professionals. My name is Jennifer Sirfas, and I'm the CEO of the Sirfas Consulting Group, and this presentation is covering what you need to know about the Sunshine Act. This is a live session. It's being recorded on March 26, 2013, and will be available for free through iTunes as a podcast or as a video archive with handouts on jensirfas.com. One quick legal note, none of the information contained in this presentation should be construed as legal advice. I encourage you to contact counsel if you have any questions regarding state or federal laws that apply to the concepts covered in this session. At the end of this presentation, I will cover questions submitted during the live session. For live participants, please submit your questions throughout this presentation using the questions box on your screen. So with that, let's go ahead and get started. So the Sunshine Act, for those of you who aren't aware, is a very interesting piece of legislation that comes out of the Affordable Care Act, and I'm going to get into a little bit of what that is. And I'm going to be really ambitious and try to cover in 15 minutes what this means for physicians and teaching hospitals and what really you need to think about before August 1st, 2013 in your relationships with pharmaceutical companies, manufacturers, and group purchasing organizations. So let's get into the meat of this. The Sunshine Act, again, if you're not familiar with this is a baby of Senator Grassley from Iowa, and this is a law that was incorporated into the Affordable Care Act. When the Affordable Care Act was addressed as part of the Supreme Court review of the constitutionality of that law, it was, again, determined to be constitutional, and therefore, guess what? We now get the joy of working through all the pieces of the Affordable Care Act. Some of them are probably going to make us all have gray hair, and others are going to be things that in future years, likely most Americans don't even realize are part of the Affordable Care Act. But this specific provision was put out both as a proposed rule and then a final rule, which was issued very, very late after a lot of pressure, several congressional hearings, and a great deal of pressure from Senator Grassley. The final rule came out on February 8th of this year of 2013. So what does it do? It requires pharmaceutical companies, manufacturers, and group purchasing organizations that have physician ownership to report transfers of value or ownership interests. Now, notably for pharmaceutical companies and manufacturers, those transfers of value or, again, interest needs to be for anything that's more than $10 an individual transfer or $100 a year. So the way to think about this is that it is okay to accept a pen from a pharmaceutical company or manufacturer. Don't worry about that. It's under $10. But if you happen to accept more than $100 of pens in 1 year from that pharmaceutical company going to one physician, that would be a problem. So again, the concept here and the reason it's being done from a public policy standpoint is that there was a perception of a conflict of interest between pharmaceutical companies and manufacturers, especially in off-label uses where they were being paid through different modalities, and these physicians therefore had a vested interest in the utilization of these either drugs or devices in a way that the public should know about. So the law requires that the data that's collected from these manufacturers and pharmaceutical companies and group purchasing organizations is going to be reported on a public website, and then the public gets to review it and use it however they feel necessary. So it's more of a consumer protection. Physicians are going to be given the opportunity to review the data. One of the reasons here, again, is that this is important because if there's an error in the data, the physician is going to have the opportunity to correct that information. But if it's not agreed upon by the pharmaceutical company or manufacturer, that data does stay out there. So this is going to be a very interesting situation, and it's already begun. So I'm going to show you some examples about this, and also just, again, what you need to think about as you're moving forward. The first data collection cycle begins August 1st, so many of the pharmaceutical companies and manufacturers have begun to think about how they're going to collect the data, how they're going to report it, and also how they're going to share this information with physicians and teaching hospitals. The first cycle ends December 31st, so it's only going to be a couple months of data, and then that is going to be submitted to CMS by the pharmaceutical companies, manufacturers, and GPOs by March 31st. There's a 45-day period for physicians to review any disputed data. If the data is disputed, again, it's going to be published, and I'll have a little asterisk on it, and I'll tell you a bit more about that. And then the final data is going to be published on September 30th. And the go forward, so starting in 2015, the data will be posted on June 30th of each year. So this is going to be an annual reporting cycle. Again, this is going to be a large database that's available on the CMS website to consumers. And really, quite honestly, this is going to be a source for journalists to find stories about local physicians. But I'll give you some examples. One that actually came out yesterday, which was March 25th. So who's included, what's included? Any product that is paid for by the Medicare, Medicaid, or SCHIP programs, the way to think of it is that if it has a federal dollar that covers these products, it will then be covered by this reporting regulation, and therefore the pharmaceutical company or manufacturer that has that product or distributes that product, they then are going to have to look at the monies that are given to physicians. And again, we'll get a little bit more into that. One of the interesting things is that this is only to physicians and teaching hospitals. So physicians is defined consistent with the Medicare program. So this includes MDs, DOs, dentists, podiatrists, optometrists, and chiropractors. This does not include residents, and it doesn't include non-physician practitioners. So nurse practitioners, PAs, PTs, anyone that's not an MD, DO, dentist, podiatrist, optometrist, or chiropractor. Any of those transfers of value are not reportable. But again, think about it a little way, is that you can't necessarily get around this regulation if these other practitioners are receiving the transfer of value, because likely the rule will say that it splashes over onto the physicians that are supervising them or located there on site. One of the questions that came up and submitted prior to this call was related to research grants. And specifically, I want to highlight for you what is research. And it's considered the systematic investigation that is designed to develop or contribute a generalized knowledge related broadly to public health, and this includes behavioral health and social sciences research. So it's a very, very broad definition. So systematic investigation. Now, research grants and other monies for research is going to be reported separately, and it may have a delay if the research is something that needs to be proprietary, maybe that there's patents related to it or there's something else that needs to be protected. And it can be delayed until it is approved by the FDA or 4 calendar years, whichever period is shorter, but no longer than 4 years. So research grants, and I'll get into what is going to be described there and what is reported, but they are considered a transfer of value and therefore covered. So what's not covered in this? So if there's over-the-counter drugs or certain lower-class medical devices such as elastic bandages or suture materials, those are not included. Gifts or payments less than $10. Again, there's the $100 annually, which is your cap. So again, the way to think of it is, let's say that your office gets notepads and physicians end up getting 10 notepads, and those notepads are $5 a piece. So that would be under the annual aggregate, and you'd be fine. But let's say that they get the really nice padfolios that are $30 a piece. Guess what? That would be reportable because it was more than $30 individually, and if there was more than one that was given, again, it's going to be exceeding, especially so let's say it's $30, so there's 4 that were received, that's $120 annually, that would be reportable. Education materials that are used with patients do not need to be included. So if a pharmaceutical company gives you brochures to share with patients about a new drug, that is not included. Also, any discounts or rebates from a manufacturer, let's say you get a bulk discount, that's not considered a transfer of value because, again, you're purchasing items on bulk. Also, samples. This is a huge issue. And just to be clear, samples that are intended for patient use, and that would include your coupons and vouchers, guess what? That's okay. That's not a transfer of value because basically you're sharing that, you're passing that along to the patient. So the physician in that instance would not have it attributed. One of the other very controversial items that came up, and CMS did respond in the over 300 comments they received, was related to speaker fees. And the final rule does exempt speaker fees so long as it is with an accredited and certified medical education program. The manufacturer pharmaceutical company didn't select the physician, and they do not directly pay them. So instead, that money would need to go to the sponsoring organization, and that sponsoring organization paid the physician. That would be okay. But again, it does need to fall into these 3 different aspects for it to be exempted. So if a physician is on a pharmaceutical company's speaker bureau, that's going to be a problem. But I do want to just give you, this is ripped from the headlines. This is a March 25th Denver Post item here where there's a physician that is specifically spiked out from a national database that highlights the fact that there was a great deal of speaker fees, over $160,000 in 1 year, that was coming from drug makers. So again, it's one of those, this is put into the newspaper. It actually gets a little more interesting here because there was a conflict of interest that was brought forward back to his employer, and the employer is now saying that they don't have an employment relationship. It's a very interesting scenario, but this is something that journalists found using this and are putting it out in the newspapers, again, whether it's true or not that there's a conflict of interest. So one other thing I want to spike out for you is that GlaxoSmithKline did pay $3 billion in 2012 related to the illegal off-label promotion and misbranding of several drugs. And then Abbott Laboratories equally did the same. What was interesting about both of those corporate integrity agreements is that they currently have to report their physician relationships, their financial relationships on their websites today. So what it does is it gives us a preview of what disclosure is going to look like. So for those of you that are seeing the video or live session, I've got a preview for you of what GlaxoSmithKline's website does look like. I pulled up from Maryland, and there's a list of physicians. They do include speaking payments on this current version because they released this before the final Sunshine Act rules came out, but they will currently still have on their websites until the national database gets there. And then again, their CIA still may not change. But what's interesting is that, again, this is out there already as a preview of what we're going to be seeing with the Sunshine Act. So the Sunshine Act does require certain things to be reported. The name of the physician, their address, and here's my personal rub. I'm really concerned. Their NPI, their National Provider Identifier, their state license number, and the physician specialty, the amount of the payment, the form of the payment. How was it a check? Was it stock? How was that transfer of value shared? The nature of the payment. Was it a consulting fee? Was it a speaker fee? What was it? And then what were the related products for that remuneration, if you will? Related to research, there's a couple other things that are interesting. So again, this is going to be whether or not the research monies were subject to a delay, the total amount for the entire study. So this is the entire payment that you receive for the research that has to be reported. The name of the actual clinical study, any of the related products, so is it related to a device, is it related to a drug? Each physician investigator, and again, for each physician, it has to be their name, their address, their NPI, their state license number, and their specialty. So it's going to be very detailed. And then the clinicaltrials.gov identifier for that specific research. So I went out to see what is out there right now. Again, this is in March. This first data is going to be pulled in August. And two things I want to spike out. So from Genentech, which is a Roche Group company, they had two things that were out there. First is that they're going to have a tool where physicians can go in and look at their data, and it's called Sunshine Track. So they're going to offer their own system that will help keep the data clean and available to physicians to review. The other thing, and this is a great question that came in prior to this session, was related to taxes. And will any of the income reported have tax implications? It is clear, again, if it's a 1099 relationship and that 1099 is going to receive, let's say, speaker fees, that absolutely is going to have tax implications. But related to these other fees, so for instance, food in the office, that right now, and this is what something Genentech put out, and I went through the entire rule, the rule doesn't address the tax implications. So until we get further guidance from the IRS, it is a murky gray area and something to talk to your accounting professionals directly about. So some other things to look about, again, about disclosure. There's two national databases out there right now. There's ProPublica. Also, there's a number of states that already have their own reporting databases. If you want to get a feel for these are likely where the national database is going to go and use these as models. So mass.gov does have another one, and for those of you on the live session and the video, I've got the mass.gov Health and Human Services Top 50 Physicians Summary. Again, very interesting reports that they have canned out there. So what do we know about the CMS website? We know that they're going to host a secure website, and it's going to give a 45-day review for physicians. You need to check, as again, physicians and practice administrators will need to double check that the data is accurate, and then you certify it for accuracy. If it's inaccurate, you'd be able to file directly a dispute with the reporting entity, so with that pharmaceutical company or manufacturer. There's 60 days from the date of release of the data to basically come up with a resolution to the disputed data. If it's not resolved, they're going to put a little asterisk on it and say that it is disputed. And then on the next website refresh, if it was resolved, they will refresh it. But that does mean that it could be almost a year, depending on how they're doing their refreshes, before that data is addressed. So a couple things that for you to think about as we close out here. The first thing is that most physicians, according to a recent study, have no idea about these reporting requirements. So this is something absolutely to bring up in board meetings and to talk to colleagues about, educating both physicians and clinical staff about the rule and the type of information that will be reported. I also encourage physician groups and hospitals to begin to survey the physicians of existing relationships so that you can begin to track this information and make sure it's accurate. Then make sure that you have policies regarding guests in the office. So for example, the way that food works right now is, let's say that there's pizza is brought in from a pharmaceutical company. There's 10 billing staff that are available and 2 physicians in the office, so that's 12 people. They would take the cost of those pizzas, and however many people ate the pizza, so let's say only 8 of them did, they would divide it by 8. But how does the pharmaceutical company, does the rep actually write down only 8 people ate it? Are you going to have a sign-in sheet? What are you going to do? These are the kind of silly things that we now begin to need to worry about because of the nature of these reporting requirements. Also, reach out to the pharmaceutical companies so you can get an idea of what they're going to be doing, how they're going to gather data, if you're going to have opportunities to review it before they submit it to CMS. And last but not least, CMS is saying that you have to sign up for their listservs to get notices about what they're doing with Sunshine Act when the data is going to be made available. So make sure that you sign up for the main CMS listserv announcements so that you can stay up to date related to that. Right now, I know we're over time, but quickly I want to go ahead and address 2 questions that have come in the live session. The first one is whether or not you need to receive the funds first and then disperse it to the physicians for the engagement. So I think 2 parts. One is for it to be a reportable act, it does need to be monies that are received by the entity, either by the physician or by the group, whatever it is. Now, if they're writing the money to the group, this is where it starts getting interesting. Generally, again, they're going to have what is the receiving entity. They'll list that, and then the individual physicians that are related to that. The manufacturer and pharmaceutical company are going to make the assumption that you make the distribution based off of whatever the contract is. So let's say that they write a check for 3 physicians and you don't distribute it to 3 physicians. They're going to make that assumption. So that's one thing just to spike out for you. So the other question is for research grants. If it's paid to a legal corporation, does only the amount paid to the individual research get reported? And how much, since the originating vendor may not have this information? And then what research organization do they have an obligation to report? Great question. It's 2 parts. So the first part of it, just to address it again, is that when that total dollar amount is paid to a legal corporation, that has to be reported by the pharmaceutical company or manufacturer. So the entire research amount is reported. Then whoever they have on the contract on those related documents. So it could be a third party or the manufacturer. The manufacturer and the pharmaceutical company have the obligation to report, not the third party. So the difficulty is going to be that whatever they have on the contract that they have with that legal corporation, so the number of investigators they've got listed, that's what they're going to report out. So that original contract, making sure that that's accurate, and if there's any changes related to reporting as you go forward, let's say a physician leaves the group or one of the other new investigators come in or leave, they need to keep that list up to date because that's what they're going to report out. The actual research organization does not have any reporting requirements. It's only for the manufacturer and the pharmaceutical companies or other wholesalers that might be involved in the distribution of those type of materials. So that's where the lines are, but it's going to be, honestly, it's going to be very messy, and it's something for you to think about over the next several months before we hit the the August 1st start of the reporting series. So the last question that came in is related to handouts. So everyone who is on the live session will receive an email with these handouts here in just a little bit. So also for those of you that are listening through the podcast, the handouts are available on jensteerfoss.com. So thank you so much for participating. I hope that this presentation was helpful. For live participants, as you log off, please take a moment to complete a brief survey so that I have your feedback and I can improve these ongoing education opportunities in the future. For those of you who are listening on the podcast, please remember to rate this recording in iTunes. And to receive notices about upcoming Gimme 15-minute programs, please sign up on jensteerfoss.com. That way I'm compliant with all of the fun anti-spam requirements. So thank you so much for joining me for today's 15-minute education program. I know we've gone over time, but I appreciate your time. And this concludes the presentation.